Members, this is the Bills Committee on Electoral Legislation, Miscellaneous Amendments Bill 2015. This is the appointed time and we have a quorum. Perhaps I ask the clerk to invite government officials to join us. Please also invite the deputations to come in as well. Today is a meeting with deputations and the administration. This is in relation to the issues raised. We're here to listen to views from deputations and individuals. After we've met with the deputations, we will continue to have discussion on the bill. When everyone's seated, I will make the introduction. We have with us from the administration, Undersecretary for Constitutional and Mainland Affairs, Mr. Lau Kong-wah, Deputy Secretary, Mr. Gordon Leung, Principal Assistant Secretary, Ms. Helen Chung, from the Registration and Electoral Office, Chief Electoral Officer, Mr. Lee Pak-hong, and Principal Electoral Officer, Ms. Candy Ma, and from the Department of Justice, Senior Government Counsel, Ms. Emma Wong. Well, the deputations and individuals have come in, and I'm not going to make an introduction, and I will state their names when they speak. Welcome to the public hearing. There are seven, right? 7 deputations and individuals. Some have yet to arrive. Let me remind you that you will have 3 minutes to speak. And may I remind you that when you make your submission, you're not protected by the Legislative Council Powers and Privileges Ordinance. In other words, you're responsible for what you say and what you have submitted. May I remind you that in front of you, you'll find an earpiece and a microphone. Channel 1 is floor. 0 is floor, 1 is Cantonese, 2 is English, and 3 is Putonghua. And those who are sitting in the public gallery, you can get notice of members of the public attending Legislative Council meetings from security staff. I will first invite deputations and individuals to speak, and then I'll ask members to exchange views with deputations. After that, I'll ask the Undersecretary or the Deputy Secretary to reply. This is how we'll proceed. First of all, let me invite convener of the Constitutional Development of the Liberal Party, Mr. Wu Hon-ching. Mr. Wu? Our Constitutional Development Task Force is a gatekeeper. Sorry, you can't hear me. I apologize. Is the microphone on? It's already on. You did not ask the central authorities in the first step whether we need to follow Article 45, that is a gradual and orderly process, if the constitutional reform proposal is not endorsed. We can't possibly remain stagnant. In 2005, there was a proposal to increase it from 800 to 1,600, and it's their problem if they don't accept it. And the government said that there is no plan B, so these amendments are just cosmetic. But the issues involved are very practical. Say, for example, Section 9, that is to change the eligibility of members in the FC. So people wonder whether it involves corporate votes. But because if the reform proposal is not endorsed, we still have to proceed in an orderly and gradual manner. It's not the case that because there is no change from what we have now to universal suffrage, then nothing can change. Well, we can't remain stagnant. We can introduce some adjustments or amendments. 50% is a problem. 2 or 3% is not a problem either. The composition is not lopsided. We're all Hong Kongers. But people think that the FC is not representative enough. Well, you told us that it's going to be gradual and orderly. So if we don't have universal suffrage, you would at least have to tell us what steps to take. We have to wait for 5 years if we don't move now. And the election method of the Legislative Council will have to wait for another several years, because it will only be changed after the CE election method has been changed. You told us there is no plan B, so it's wrong. Under Article 5, it says that constitutional reform has to be done in an orderly and gradual manner. Next, from Dynamic Island. Hello, my name is Wu. Can you hear me? Sorry, just now you asked me to speak closer into the microphone. We've always been very concerned about administrative procedures and also electoral arrangements. We welcome this public consultation, and in 2011 and 2013 there were no public hearings, so I was quite disappointed. And now we have one, and last year there was one as well. Well, there are several parts. One is in relation to the change of names in one sector. That is, one in relation to architectural surveying and planning functional constituency. Well, it is not the case that we don't respect the professional qualification of landscape planners. But we wonder why it has to be so detailed. Say, for example, education. Is it going to be a functional constituency of board of directors, school sponsors, or the legal sector is renamed barristers and solicitors? It shouldn't go this way. It should be a general term when we can tell what it's about. Well, why is it called Business 1 and Business 2? Commercial first and commercial second. Why don't the original name, that is Chambers of Commerce, is used? And in relation to District Council Second, FC, it's about the arrangements of the counting of votes. In 2012, when it comes to the central counting station, well, in accordance with a normal procedure, in these central counting stations or in well, all the counting is done separately, and when it comes to small polling stations as opposed to big polling stations, there will be separate counting. When it comes to dedicated polling stations, the arrangement in 2012 was that for the 27 dedicated polling stations will be mixed with FC votes. So there is one single table used in the counting of votes. That's why the central counting station will have to make arrangements to count the votes in accordance with the different districts. And I have some other areas to cover as well, but I don't have time. Next is Hong Kong Electoral Society Limited, Mr. Yu. Hello, I'm the chairman of this society. My name is Yu, and we've established ourselves for 15 years. Our main members are SMEs in this district, and you understand how important SMEs are. We strive to protect and promote the interests and development of our sector. Every year we organize various activities. So we do think that our members should enjoy the same standards as the other 12 or 13 bodies. We should be given the right to vote in our own sector. In June 2011, we sent a letter to the CMAB. We clearly stated our intention that we would like to become eligible voters in a textile and garment FC.
So that our members will automatically become voters of the textiles and garment functional constituency. In this way, we can enhance the representativeness of the FC. Unfortunately, at that time, we were given a very, very simple answer, saying that the notice given was too short and it was too close to the 2012 electoral election, and so there wasn't time to process the application. Now, 4 years have already passed. So far, we haven't received any news from the government concerning our application. Now, my question for the government is as follows. Now, I think I want to know about the criteria for adopting the listed bodies, and I want to know how long it will take. 4 years, I think it is unreasonable, but I'm not sure about the view of the electoral members. Now, you may very well rule that our society is not eligible, but at least you owe us an answer. Now, the electoral election is just a year from now, and I hope that the government will take the matter seriously and process our application so that our members, so that the FC for textiles and garment will have a more representative electorate. Now, if the government would like to get more information from us, feel free to approach us. Lastly, I just want to say that we look forward to a clear answer from the government. Thank you, Mr. Yu. Next, Mr. Raymond Lui from the from the Institution of Engineering and Technology. Thank you, Mr. Chairman. Thank you for giving me the time. Regarding it has been said that according to Appendix B of Registration in the Information Technology Functional Constituency FC and Election Committee EC Subsector Item 6, only members of the IET Hong Kong who are chartered engineers or corporate members of the IEE Hong Kong before the 15th of October 2002 are eligible to register as voters of the Information Technology FC and EC Subsector. we have very strict requirements concerning membership. You need to have a degree or above. Say, for example, you need to have a bachelor's degree, a master's degree, or a doctor's degree, and then you need to have between 2 to 12 years experience. You need to have proof about your qualifications before you can get registered and accepted as a member. Therefore, I believe that our membership requirement is no less than that of other associations. So we hope that all our members can be accepted as the electors of the ITFC and EC subsector. So the point I want to drive is very simple. I just hope that you won't say that just because some of us haven't been registered as chartered engineers and so we lose our eligibility. Well, in fact, we have got members who are involved in IT. Generally speaking, they don't get registered as chartered engineers because the status of chartered engineers is sort of another group of engineers. For us in the IT sector, usually we don't get registered as chartered engineers. I just hope that you will accept our request. All our members should be allowed to register as voters of the IT, FC and EC subsector. Thank you. Next, from the Professional Information Security Association, Mr. Fan. Thank you, Mr. Chairman. Yes, I would like to speak on the bill concerning electoral legislation. We have already been set up for over a decade, and you need to satisfy 2 criteria. First of all, you need to be a full member. In other words, you must have 3 years or more of experience in the sector. Second, you need to have passed the CISSP. First of all, you need to have 4 years specified experience. That is 2 out of the 8 areas of the CISSP. And having taken the membership, you have full membership, and then you have to wait for another 4 years, 3 plus 4 plus 4. In other words, you need to have over 10 years experience before you are entitled to a vote. In the year 2007, we already asked for a change. That is, we should be spared the 4 years waiting time after having passed the exam. Here, we would like to put in 3 points. First of all, please listen to us. Please give us an answer as to why it has taken that long to process and vet the application. If necessary, we're happy to provide further information. Thank you. Thank you for your time. I would like to thank the 5 deputations and individuals who have spoken. I would like to check with members if you have got any questions for the deputations or individuals who are in attendance, or whether you have anything to exchange with them. Charles Mock, Emily Lau, Felix Chong, and Sin Chung Kai. 5 minutes each. First of all, Ms. Emily Lau. Thank you, Mr. Chairman. I would like to thank the deputations for giving their comments. Now, for the political reform package, of course, we know that it has become a mess, all because of the government, and the society has been very much divided. Mr. Alan Hu has suggested that we need to emphasize gradual progress. I would like to give him time to elaborate on this point, assuming that the package will not be voted in. Now, for the local elections, I think we expect something to be done. We can't simply say that it was improved last time and so there won't be any improvement this time. You have food every day, right? Now, I know that Mr. Hu is in charge of a particular center for basic law. Now, please, assuming that the package is not endorsed, I want to know whether the government is duty-bound to do something about the electrical elections. In 2016, there will be a electrical election. So what is your suggestion? Mr. Hu, let me answer Emily's question in principles. Article 45 of the Basic Law is very clear. You don't need to ask the SARG, the Beijing administration, the Hong Kong Macau Affairs Office, or those in the Western District. It is very clear. It talks about the actual situation. Who is to define what is meant by the actual situation? Of course, the SARG, in particular the CE, because the CE has to implement the basic law. This is what is required of him under Article 48. So for the 5-step process, for the first step, it is in the hands of the SARG. Beijing government will take the second step. So they are not proactive, they are reactive. It is up to the SARG to report to the Beijing government about the actual situation in Hong Kong and also the SARG's view concerning the governance, concerning the circumstances, whether there should be a change in the composition of the electoral. So for the first step, it is squarely in our court because you need to do homework before you trigger the 5-step process. Well, last time there wasn't effective work in building up solidarity and consensus. Now this time you have to work harder. You can't simply say that the society is divided. If you don't tell the society clearly what the next step will be like, you can't simply dismiss it by saying that it will affect the relationship between the SAR and the CPG, and so we need to mark time and there shouldn't be any forward moves. I think this is being irresponsible. Now we are in the third step of the 5-step process. First of all, let me not ask the question why there hasn't been a plan B. Now, under Article 45, it doesn't say that if the reform package is not endorsed, we can just sit idle. Now, there were calls concerning changes to the corporate votes. I think there should have been some initial discussion. And then for the agricultural and fisheries sector, should it be given 60 votes or not? Mr. Hu, now in 10 days' time, we are going to vote on the matter. So what you are saying is that even it is voted down, the government should have come up with a plan B to tell us what is to be done. Is that what you are saying, Mr. Hu? Well, what I'm saying is that if the package is not endorsed, so perhaps there should be an amendment so that the SARG will commit itself, so that the composition will be improved on a gradual basis, so that we meet international standards, so that we'll have genuine choices. So we should move forward on a gradual basis. Now, 40 out of the 70 seats are elected members via direct elections, 35 plus 5, so 40 out of 70. So it is not contravening universal suffrage. I think the government is duty-bound to do so. Now, the Hong Kong government, the Hong Kong society must tell the Beijing government what we want to do to move forward. So for the first thing to be done by the CE, even if this is voted down, we mustn't allow the division to remain in the society. We mustn't shove the matter. We need to get more people so that we can move forward. I don't think the constitution in PRC is that complicated. Mr. Charles Mock, I'm interested in the idea of gradual and orderly progress mentioned by Mr. Hu, but then I would like to embark on something else first. I think last time I asked the Undersecretary a number of times concerning the IT sector. We have got the IET as well as PISA. Well, there were in the past 3 such organizations and 6 other new members. I have already asked them to submit papers to the government well in advance. Now we have got 2 deputations here. Both of them have made the case clear. Now we have got Mr. Sin Chung Kai here. And I must say that in the year 2007, when the Electoral was having a public hearing, at that time I was at public gallery. I was looking at Mr. Sin Chung Kai. A number of associations, including the 2 here, made the same point. So they were already on this matter back then, but we haven't made any move forward, not to mention gradual progress. I think for the IT sector, we have always been left to mark time only.
Well, this has been discussed over a long time. As when it comes to the issues raised by IET, they're rather complicated because it involves the eligibility and the charter, and also changes between them and the UK head association. But I'd like to ask the 2 gentlemen. The administration gave us a paper saying that when it comes to the requests from the information technology sector, the CMAB consulted the Commerce and Economic Development and the OGCIO. So I'd like to ask the 2, over the years, and especially during recent times, the CEDB and the OGCIO, as well as the CMAB, did any of them contact your institute or your affiliation or your affiliated bodies to try to understand the situation? Did they ask you questions, and did you have the opportunity to provide information to them? You can think back to maybe 2007. 2 minutes, Mr. Liu, please. Our institute is very active in participating government work when it comes to IT development. Say, for example, the IT Fest, and we've also entered in the competition representing Hong Kong to go to the US. And we have also submitted consultation papers and also some cooperation activities. We spare no efforts in promoting the development of our sector. While I myself may not be a very high-ranking member in our institute, and I have not personally been contacted. So you've never been contacted about this? Well, not me, but I can't speak on behalf of the institute. But I myself have never heard anything like that. Next, Mr. Fan. Well, I can give you a direct answer. Starting from last year, I become the chairman of the External Affairs, and this year I become the chairman of the association, but I have not heard about any inquiries made of me from the government. Our former chairman is in close contact with me, and as far as I know, the former chairman has never received any requests for information or inquiries. So is it the case that, the government has to make changes, and I support that. If the government arrange a meeting for the 3 associations to explain your case, would you like to participate? Yes, absolutely. And I'll be very happy to. Mr. Chung Kwok Pen, to be followed by Mr. Sin Chung Kai. Well, I have some questions about constitutional development, but for now I have some questions about the sectors. Mr. Fan and Mr. Yu both told us that they have made an application a long time ago. They asked to be a voter in their respective sector. For both of them, the government have not given them any answers. So can the government explain why they don't even give them an answer? So what's your criteria for consideration? That's a question I have, because we're talking about two different, two chairmen from an association of two different sectors. Mr. Secretary, anything to say in reply? Can I give an overall answer? Mr. Chung, well, perhaps let's hear from the Undersecretary first, because I don't want him to forget. So you're now asked to reply. When we receive applications of this nature, we will consult the relevant policy bureau, because they are in a better position to understand the situation, and then we will consider the views they expressed. And that's always been our approach. When we receive an application, we consider it, and we have to wait for the legislation to be endorsed before we give a final answer. Prior to that, we will give them preliminary answers. That's our usual procedure. Mr. Chung, anything to say in follow-up? The thing is, the two different associations said that they have not received any reply from the government. So how can the government say that you have consulted the relevant policy bureau? Even if you have to give them a reply. But so far, the two associations said that you have not replied to them at all in the past 3 or 4 years. And the Secretary, which department is responsible for making a reply? If Mr. Chung is talking about the March 2011 letter from the Hong Kong Electoral Society Limited, well, we have actually sent them a preliminary reply in June 2011. What about the other one? Have you replied to them? We've only received the letter from the Hong Kong Apparel Society Limited. Mr. Chung, Mr. Yu said that they have received a reply, but that was 2011. So you have not replied them again over the past 4 years, Undersecretary. As I said, we have to wait for the legislative amendments to be endorsed before we make an official reply. Mr. Sin Chung Kai, to be followed by Mr. Loy Kwok. Well, that means that you have to wait for another 4 years. I think, you're quite humorous, Undersecretary. Let me answer on behalf of the government. Well, if increasing the electoral base is favorable to the opposition, then of course they are not going to do it. You've always been seen as a loyalist. You have to do something about it. You have to promote orderly and gradual progress. It's the Liberal Party. Well, you told us that you don't expect it to happen overnight. But can you give us more details? So I think it's the proposal of the Liberal Party to change the corporate vote to directors' vote. And of course, some other people propose it to be individuals' vote. I think the electoral base for FC is about 200,000. So, how many more do you think there will be if there is an increase? Under Article 45, there are 3 basic policies setting down the framework of the selection of the chief executive. Of course, the first one is a gradual and orderly progress, and then there is the actual situation has to be taken into account, and there is also the balanced participation. Now, 1984, before December, before the joint declaration was signed, there was a blueprint. It's called representative government, representing constitutional situation. Well, there is one vote. It's on the basis of where you live, and there is other one is a functional constituency. You can't simply abolish the functional constituency, but you can do so by gradual and orderly progress. But if you remain stagnant, then you're just wasting your time. What you can do, well, back in 2005, the government submitted the first step, that is an increase from 800 to 1,600, taking into account the actual situation. Yes, you have to follow the principle of balanced participation, but it doesn't mean equal participation. If it's equal participation, then the form is set, is like it's etched in stone in relation to the 4 sectors. But if you say that there is actually a blueprint, and to expand the sector of a political party, so it was 200 for the first 3 sectors. Is just an increase by 50, but for the 4th sector, which is in relation to political parties, there is a bigger increase to 700. And of course, with the August decision framework, well, there is an equal number. But it doesn't mean that now equality means equal number means balanced participation. But it means that you can't introduce significant changes. There is constitutional responsibility to make a submission to the central authorities, indicating that we still want gradual and orderly progress. You can't say that, well, we'd rather remain stagnant. I don't think that is the constitutional duty of the Hong Kong SAR government. That's why I asked the government, if the actual situation is suitable, should we continue with the 2005 proposal, that is to increase the 4th sector, to allow all 400 district councillors to become voters, take a gradual and orderly progress, and in the end it will be like Western countries, that there will be nomination by political parties. Of course, you have to take into account the actual situation. And that is in reply to Mr. Sin's question. That's the first step. So is it in compliance with the basic law? Of course, if it's stagnant, then it is not in line with the basic law, because it's specified clearly that there should be gradual and orderly progress. Mr. Ma Fung Kwok. Mr. Lo Wai Kwok. We have Mr. Ma Wai Kao. He sent a letter to us, signed by him. It's a Raymond Lui. He signed it. It's from the Institution of Engineering and Technology. Is this a collective view of the institution, or is it a personal view of yours, Mr. Lui? What is the view of the institution? Because it says there is a section committee on the letter. Well, there is a branch committee in the institution. Branch committee is the highest level body of the institution. So this is the view of the branch committee. I represent IET. So you represent IET Hong Kong branch? Yes. That's the point I would like to clarify. Mr. Ma Fung Kwok. Last time I was out of town, so I did not attend the meeting. But I have some questions to ask. It's actually a question forwarded to me by a body in a sector. There is a Chamber of Commerce, printers. They told me that over the few elections of FC, they somehow become voters from the insurance sector, and they do think that insurance and printing are very different, and they think this arrangement is incorrect, and they wonder what the reason is. Prior to the last election, this body reflected their views to the administration. They think the closest FC is a sports, performing arts, culture and publication functional constituency. They think that if they belong to this FC, it will better reflect their position. But their request was not heeded by the government in the last election. And they have made a submission when they expressed their views in the constitutional reform. And I would like to draw the attention of the Bureau. So far, the Bureau has not responded to this. So my question is, how come they become voters of the insurance sector? And is this a special case, or it happens with other subsectors as well?
Undersecretary, I'll just see if Mr. Lee Pek Hong would like to give an answer. Yes, Mr. Lee. Regarding the insurance, I think the mic hasn't been switched on, so please be patient. Perhaps I think in terms of the control, I think there has been some delays, so please bear with us. Well, for the insurance FC, if a company has been authorized under the insurance ordinance as an insurer, then it will be an eligible voter. The insurance FC is a special FC. So if an organization is eligible to be registered as an elector under the FC, then it has to remain in the FC. But then it is from the printing industry. How come that it is a voter, it is a elector in the insurance sector? If one is eligible for both FCs, then if one of the FCs he is a special one, then the special one will have priority. Well, that association has already said that it prefers the other FC. There's the publication FC. Why is it so? Yes, Ms. Ma. Ms. Chung. Yes, we have got this letter from you, Mr. Ma. We will study the details and we'll give you a reply. But then the bill is soon to be enacted. Well, let me just briefly explain this matter. For the Chamber of Commerce, for the printing industry, currently it is in the insurance FC. Well, in fact, according to the insurance ordinance, it is an organization which has the status as a recognized insurer. And in fact, in the past, it has been taking up insurance responsibilities for its members. Now, Mr. Ma may say that this body is eligible for the publication FC, but it is also eligible for another FC. Can it have freedom to choose one out of the two? Well, according to the existing electoral ordinance, well, there is a clear provision. As Mr. Lee has said, there are 4 special FCs, and therefore we don't have a large number of electors in those FCs. Therefore, they are called special FCs in the ordinance. Now, according to the electoral ordinance, we have got section 25. If an organization is eligible to be registered as an elector in the FC, if it is a special FC, then you have to stay in the special FC. But then the publication FC is for publication and printing, and this organization has asked for it to be given recognition in the publication FC. Why are you not heeding to their heeding their request? Well, as I have said in the past, they have underwritten. Well, if they have printed a book on entertainment, does it mean that it will go to the entertainment sector? Mr. Yip Kin Yun. We have got matters arising, so I want to know if this is the right time to do so. Last time, I would like to have a list of all the eligible ranks. Well, towards the end of that paper, it is said that the provision stipulates that information obtained may only be used for the purpose of preparing a register or in specified occasions or legal proceedings. We are thus not in a position to disclose the requested information. It is very much mind-boggling. We are not asking for the information of the electors. We do not think that we can get the information of the electors. What we want to get is a list of the eligible ranks so that we can check if we have got any inconsistencies among the different institutions. We are particularly concerned as to whether some have been left out. The information has been supplied by the institutions. We do not intend to have the personal data of individual electors. Just now, I have quoted from your reply. You have said that the information obtained. Are you actually referring to the personal data of the electors? If that's not the case, do you think that you will be in a position to disclose the information? Well, for this session, it is about having a discussion with the deputations and individuals. For the point raised by Mr. Yip Kin Yun, I think it can be dealt with later on in the meeting. But then since you have asked the question, I think it's better for me to give the floor to the government and give us a brief reply. I just want to tell members that please make use of the time available in this session to exchange with the deputations and individuals. Could I to answer this question, Mr. Lee? Within each voter registration cycle, we will ask the institutions to have a list of the ranks and the relevant information. This is done, that's been done in accordance with the law. So the institutions have given us the information in accordance with this provision. Some personal data is involved. Under the electoral law, there is no distinction between the two types of information. Anything submitted by institutions to us for voter registration, there is a restriction there. That is, it can be used for two purposes. First of all, for the preparation of a voter register or investigations or legal proceedings under the relevant ordinance. We have consulted the views of the DFJ after the last meeting. It appears to me that we do have difficulties in providing the information to a third party if it is information supplied to us by institutions in this regard. Mr. Yip Kin Yun, let me clarify. Were you talking about personal data of the electors? But then we are asking for something extra, and it is related, but then it is something extra. When the institutions provide the information, I'm sure the information will be based on the ranks. So we want to know about the list of eligible ranks. Can you ask this to be supplied to us so that the provision of the information is for one purpose only, that is for referral to the electoral. So I want to know from the government whether it is possible for you to ask the institutions to give the information rather than asking you to turn in the information you have obtained earlier under the ordinance. Mr. Lee, for information provided by institution under the law, well, we have the names of the eligible voters, and we have got the personal data like the contact information, ID card numbers, as well as the ranks. Therefore, as I have said, it is being sort of governed by the relevant provision. Now that Mr. Yip has got this request, we have to study as to whether it is appropriate to do so. Under the law, I've only got this duty, I've only got this right, that is, in accordance with the law. In accordance with this piece of legislation, I ask the institutions for information. If I do anything outside that, perhaps I should talk to the Bureau to see whether we should be demanding the information for referral to the Electoral for reference. I'm afraid that if both are lumped together, institutions may have their own position because they have been providing information in accordance with voter registration. Mr. Paul Chair. Thank you, Mr. Chairman. On this occasion, this is a bill which is about the technical amendments. Personally speaking, other than paragraph 19, which is about relaxing the time allowed for instituting prosecution, I haven't got much to comment on. I think the Chair, you have been very sort of lenient, and anything related to elections can be asked, and including views concerning the CE election have also been allowed. And for the FC membership, some of us have got certain views. Mr. Ma Fong Gok has talked about the mismatching in some of the FC sectors. Well, in fact, from time to time, when we consulted the views of different sectors, we've been surprised by the different views. Say, for example, building management, cleansing work, etc. They've always said that they have a very strong force, but then they haven't got their voice represented. And of course, there have been mismatching. And then chiropractors are not in the medical sector. Rather, they are in the health services sector. I think it shows that for many years, the government has allowed FCs to be smeared, and FCs have been regarded as monsters. This is all because the SARG has been too lazy, and the SARG, since the return of Hong Kong to China, has never sorted out and improved the EC subsectors as well as the FCs. So what they have been doing simply follow what has been decided well before 1997. We are doing harm to the FCs. I think FCs have this role to supplement the inadequacies of the GCs. This is a very innovative idea, and this is supplementary to the representative proportional representation. I think even the UK, which has a long history of democracy, would like to have the proportional representativeness. Now, the FCs have been criticized just because the government would not improve the proportional representativeness. I think we can do something about it. I think it is simply a legacy from history. Unfortunately, for the Agriculture and Fisheries FC, it has always been cited as an example. It has got 60 seats. There are other sectors that have played an equally important role in our economy. I think you should have given them a chance to participate early, and they should be given a seat on the election committee. Just now, some of the deputations have told us about their dissatisfaction, and Mr. Alan Hu has even said that this is breaching the spirit of gradual progress. But my main point is that for functional constituencies, I think they cannot be easily set up elsewhere. This is because we have got vested interests with direct elections, like in the case of the UK and the USA, when they have direct elections. If all out of a sudden you would like to introduce the idea of FCs, it means that the political parties have to give up some of their powers. Of course, they won't allow it. And then for FCs, it is difficult to sort of divide the spoils, so to speak. Once a seat has been given, once powers have been given, it will be difficult to ask for it to be returned so that it can be given to a new FC. In the 1980s, at the time, people were ignorant and they were not keen about politics, and so they didn't quite care about it.
But the situation is different. Every sector tells you that we are influential. You have to give me something. Well, you have to come back to the issues raised by deputations today. We have Charles Mok and Chung Kok Pan. If there are no other members, I'll draw a line here. When you speak, please focus on the issues raised by the deputations, because if it involves the administration, we have plenty of opportunities to have a discussion with them. We have Tony Tse and Emily Lau. I'll draw a line. There won't be any third round. We still have plenty of time to discuss with the administration. Mr. Charles Mok. Well, I would like to ask questions of the deputations. First, Mr. Hu, you talk about gradual and orderly progress. Well, next week, there will be a vote on the constitutional reform. It's very likely that there won't be any progress. And if there's no change in the 2016 Electoral formation, then the election committee now for 2017 will still be an election committee and not a nomination committee. There is actually an opportunity. The election of Electoral in 2016, the FC, there is actually a proposal, is supported by the Liberal Party as well, to change from corporate votes to directors' votes. And at least you can introduce this change first. Perhaps when the election committee is changed to nomination committee, maybe the representativeness will be higher. So would you support changing corporate votes into directors' votes in the 2016 Electoral election, Mr. Hu? What if we are asked to support a change from the Green Paper, not just district council election, not just electoral council? If you speak to Chatham House, international studies institutions and think tanks, that we're still bogged down with the nomination rights and is detached from the main issue, and it doesn't work.
我哋呢個模式要睇喎，你而家阻住。
It's already clearly stated that, first of all, there is the CE election before the electoral election. So is there a case for Hong Kong or not? So I think Mr. Hu means is first there should be a universal suffrage for CE before there is a universal suffrage for electoral, and it's not first change from corporate vote to directors' vote, It doesn't mean that it will have to start with the nomination committee. It can start with electoral first, and then next we will do something about the nomination committee. The first step of the 5, well, Hong Kong's situation has to be taken into consideration, and I think that that should be a change from if you say that there is going to be a change from universal the nomination committee, and if you say that there is no consensus, and if you still get bogged down with civic nomination, then you won't get past the third step. I think it is not the right time. Perhaps you would want to enhance it further. Or perhaps you say that let's just abolish it. That is a case because time is changing. It's a positive process, and it's something we have to do. If the first step is to improve the current composition, then of course it will be endorsed. Then that is orderly and gradual progress. But no. You want to get the best in one go. Universal suffrage, equal voting, something that even the US don't have. But there is no consensus. You have to move forward. But how? Is it the case that the trio will disband after the proposal is endorsed? From what I can comprehend, Mr. Hu said that when it comes to constitutional reform, it has to be done proposal on an individual basis. And well, you can never you don't say that 2016 is related to 2017, and I don't know why the government will only focus on just one thing, and as a result, we remain stagnant and we can't move forward. If you want your proposal endorsed 2016, 2017, you have to do something about 2016 election as well. Mr. Chung Kok Pan. Well, whether the proposal will be endorsed or by some miracle whether the proposal is voted down or by some miracle is endorsed, at least we need to make some progress. Can we establish a platform for people with different views to sit down and talk about future improvement? You need to have the ability to bring people together. Mr. Tam rejected the idea and said that it won't happen. So I would like to ask the Undersecretary again, if you all think that there should be some kind of solidarity, you should bring people together, and there needs to be some improvement, some orderly and gradual progress. Is it the case that the government will still reject the idea of establishing a platform? I don't have anything to add to what the Secretary has already said. Mr. Chong, anything to add? Yes. How can you just say that you don't have anything to add? And I have a question for Mr. Wu. You talk about improvement, you talk about bringing people together, but the government rejected the idea of a platform. So what do you say? Mr. Wu, let's look at it the other way around. The 1,200 election committee, if it becomes an ultimate option, is it in line with the basic law? No. Obviously not. How can an election committee become an ultimate option? But if this is the way we proceed, then that will be it. Because every time we won't move an inch forward. You don't explain to society, you don't encourage the public to start discussion, to move forward. You will abandon discussion because there won't be any result. It seems that you're penalizing society, but the government has the duty to make things right, to bring it back to the right course. You have to at least maybe form a working group to take the first step. You don't have to jump all the way to civil disobedience, Occupy Central. Why don't you encourage a rational discussion? Why not establish a platform? We don't need Hong Kong to create or invent a universal suffrage because we have a lot of overseas experts. In the end, it's Hong Kong that suffers. So why isn't there a working committee, whatever topic it is, corporate vote or whatever? Why not start the process first? Because if you start the process, it will narrow down the differences. Does the government think that the current situation is good? Why not use a platform to try to do something? Thank you. Mr. Chung, anything to add? I would like the administration to reflect Mr. Hu's view to the trio, because we're talking about the good of Hong Kong. It's not the case that once the work of the constitutional reform is done, then the work of the trio is done too. Anything to say in reply? No. Mr. Tony Tse, followed by Miss Emily Lau. Mr. Paul Tse, followed by Miss Emily Lau. Well, I don't rub shoulders with the legal party, but well, I don't fully grasp what Mr. Hu said. He said that the election committee is not the ultimate aim. The composition itself can be improved constantly, but if the government refuses to do that, I proposed in the first stage consultation that the election committee can be injected with more democratic elements. At least we shouldn't give the impression that it's very biased. 100 years ago in the US, there was public nomination. That was before there was a political party with sufficient public mandate. The elite of society will screen candidates to run in a presidential election. Because ideally there should not be more than 2 or 3 candidates in the election of a state leader. Otherwise it will be like a circus. You will lose focus. A lot of people use Iran or North Korea as examples, but it's meaningless. Even the US election has screening. It's just that it's more democratic and it's more acceptable. It's changed from public nomination 100 years ago to now party nomination. There has been 6 times when there was civic nomination, but no one was returned. So it was more done in form than in substance. Well, in a democratic system, it's acceptable to have some kind of screening. Of course, there is a lot of room for improvement in our system. And even if this constitutional reform is not endorsed, we need to actively find other ways to do something. Under Secretary, you were once a legislator. You fully appreciate the difficulties and the merits of direct elections. Every time the government said prior to election that there is not enough time, and after election they say, well, there's plenty of time. And as a result, nothing is done. It's very undesirable. Under Secretary, you have plenty of experience in direct election. Perhaps you can make some suggestions and do something about it. And I'd like to ask Mr. Alan Hu, if you want to improve the functional constituency, say for example the legal sector, now there are only solicitors and barristers or government counsels. If there is any improvement of the FC, do you agree that people who've worked in this sector for many years, say for example legal clerks, tea lady, or secretaries, if they've been serving in the legal sector for many years, shouldn't they be voters? Do you agree? If not, why not? Well, if we look at it from the perspective of the common law system in Hong Kong and the single system on the mainland, should this sector be called legal practitioners or legal professionals? If it's legal practitioners, then social welfare officers or those who compile background reports, those who work in courts, belong to this sector. But if you draw the line at professionals, then all prosecutors should be included. Let's forget about the nomenclature. What about all the people who worked in the sector? I support professionalism. Say, for example, if it's a legal secretary, if you are qualified professionally, then you belong to this center. If you're only a tea lady, then no, you have to draw a reasonable line.
Oh.
So whether they are foreign lawyers or not, as long as they are working in the field, they should be admitted. Ms. Emily Lau, for years we are not interested in the functional constituencies. Now the printing Chamber of Commerce has been registered as a member of the insurance FC. I think that's all because it is very special. There are just dozens of voters in a small FC. So, Mr. Yu, please tell us what you expect the government to do in relation to the small circle election. Mr. Yu. Please switch on the mic. Well, Ms. Lau, as you know, it's not for him to switch it on himself, so please don't get so impatient. We represent the sector. We hope that there will be an expanded electorate for the FC, so there will be more representative. I'm grateful to the Undersecretary, Mr. Lau, for his speech, but I just have to put this question to you. How many decades do we have in one's lifetime? We have waited for 4 or 5 years. Just now, Mr. Lau's reply gave me the impression that perhaps for the coming election, our society might not yet be admitted as an elector. In other words, another 4 or 5 years. So by then, we will have waited for 10 years. So it's better for you to wait for universal suffrage. Mr. Lui, we hope that all our proper members are eligible for the ITFC. For our society, for our institution, well, in fact, we have had international standards, and it has a history of 100 years. We have got very strict or stringent requirements before we admit somebody as a member. Therefore, we would not say that we fare less than the other IT organizations. Thank you. Next, Mr. Fan. Sorry, Mr. Fan. It's better for me to invite them to speak, but that is my time. But that I'm chairing the meeting. Thank you, Mr. Yip, Chair. On behalf of our association, I have to say this directly. For 8 years, we haven't received any inquiries from the government. They haven't taken the initiative to contact us. For our association and also myself are also members of the OCO. But then we haven't got any news from the government. We are not pressing for immediate eligibility, but at least you owe us an answer. So, well, what sort of efficiency are we talking about? So let me state our case once again. We look forward to a speedy reply from the government. Emily, I think Mr. Hu would like to speak. Yes. It seems that Mr. Wu, I think it seems that we have digressed. How come that we have got special FCs? We have got 4 FCs that are special FCs, Heng Yi Cook, insurance, etc. Say, for example, I'm a district council member and I'm a lawyer. I cannot get registered as a lawyer. I have to be in the DC FC, and it is rubbish. How come that you have the DC1 and the DC2? How come that you have a special FC? I think it's up to me to exercise my choice, unless you say that I'm not eligible as a voter. If you think that I'm an eligible voter, how come that you deny me the right to get registered in another FC? How come that some organizations responsible for printing should get registered as a voter in the insurance FC? And then, of course, we understand that there has been a change in the way that we mark our ballot papers. I think last time we already put in a submission relating to the electoral arrangements. How come that you don't give us stamps with the numbers 1, 2, 3, 4 marked on them? And when we have got 2 candidates only, why can't we just put a tick next to our choice? We have got 14, 15 pages of submission, but it seems that nothing has been taken on board. All right. I think I draw a line here regarding the discussion with the deputations and individuals. I'd like to thank the deputation and individuals who have attended today's meeting. I'm sure with your input, we have been getting more and more information. So thank you, and you may now be excused. I want to know if the government is going to give a written reply to the questions asked by the deputations so that we have a complete record. Yes, it will give a reply to us, and I'm sure we can forward it to the relevant individuals or deputations, so they'll give an answer to the Bills Committee. Thank you. And then just now, we were mainly receiving views from the deputations and individuals. Now let's come back to our own work, and I'll give the floor to you so that you can continue to tell me about your concerns regarding the bill itself. Any comments for this bill? Do you have other questions? If not, then we can start the clause-by-clause scrutiny. Mr. Paul Chair. Thank you, Mr. Chairman. Let me come back to a point that I've touched on, and that's about the EAC ordinance. And then the time limit of 6 months will be removed. So I want to know whether you can now have indictment, and so you don't need to abide by the 6 months time limit. Is it within this bill? No, my understanding it is not. No, I don't think that point is related to this bill. It is outside the scope of the bill, and therefore probably you have to take it up elsewhere, say for example at a meeting of the Constitutional Affairs Panel. Well, in this case, my brief is such that unless I've got the wrong file with me, this bill is mainly about the amendments to the names of the organizations and the lists. Yes, I will try to sort it out. Maybe it's my fault. I'm sorry about that. If there aren't other questions, then we can start the cross scrutiny. Mr. Chairman. Yes, indeed. If I may add to my earlier question, I asked this question. First of all, the arrangement has been unreasonable, and I don't know why the government will not want to rectify it early. I just want to point out that the consequences can be grave, because if you allow this to continue, then it means that you are enhancing the ammunitions of the critics of the functional constituencies. For the functional constituencies, they're meant to represent the voice of the relevant sector so that the electoral can get input from the sector. Now, if the sector itself is unhappy about the electorate arrangements, then it is meaningless. And I hope that the government officials will take the matter seriously. I don't know why they are unwilling to change. We have been told about the reasons, say, for example, they meet certain requirements, but I don't think I've been convinced. Every time when there's an update of the electoral laws, I think this is exactly the kind of revisions that should be carried out so that the FCs are more representative. Otherwise, in the long term, you are just doing harm to the FCs. So this is the point I want to raise, and I want to tell you why I have such strong views. Maybe after the meeting, we'll have a direct dialogue with Mr. Ma. We'll bring along the text of the electoral law. Moreover, it seems that you have met them, but you haven't given a reply at all. Say, for example, a letter was sent to you, you received the letter a few years ago, and so far you haven't come back with an answer. This is undesirable. Well, other than the case mentioned by Mr. Ma, for the other cases, once the bill has been enacted, we'll also give an overall reply to the other persons who have given a submission. Ms. Emily Lau, it's fine for the Undersecretary to talk to Mr. Ma. It's all right for you to have a dialogue, but you have to come back to us. You need to give us information. Tell us how you're going to address the problem he has outlined, as well as the questions asked by the deputations. I want to know whether there is still time for you to sort out the matter before the next election. But of course, maybe you will be adamant and you will simply say that the bill has been passed, and so they better wait another 10 or 8 years. Mr. Lau, Ms. Chung has already given a very comprehensive answer, but regarding the provisions themselves, I think it's better for us to show a copy to Mr. Ma, and then he can be clear about it. We are not dealing with any special sort of arrangements. What about the other deputations questions? Well, in our discussion with members, I think we have already addressed the concerns and we've given an answer. As I have said, after the bill has been enacted, we are going to give a reply to all those submissions. Are you saying that they will be incorporated? No, we'll just give an account. We'll give a reply. after hearing the views, the government will give a reply. Well, regarding the point raised by Mr. Ma, well, the purpose of the bill is to enable the government to hear our views. So, citing Mr. Ma's example, say we have got this organization. It has got very strong views. We're talking about special FCs. Yes, they need to be treated in a special way, like the District Council 1 FC. As a DC member, if somebody is a voter under DC 1 FC, of course, the question of representativeness is clear. If a person has got other qualifications or eligibilities, then it is something else. For Mr. Ma, I think in your example, it is quite a different case, because that organization doesn't think that it belongs to that FC. I think there's one common point among the deputations, that is the government hasn't given an answer in time. You may disagree with us, but I have to point out that there have been very strong views.
After the consultation or the public hearing, the administration will consider the views and think about whether there needs to be further amendments. I do hope that they will take that into account. If it's fully justified, and if you still don't consider it, I think it's rather inappropriate. Mr. Charles Moff, to be followed by Mr. Paul Tse. Well, it seems from what the Undersecretary said that he will only give an consolidated answer. Does it mean that once they've given the consolidated answer, there is no room for further discussion because it's already decided? If that is the case, there is no need for us to have any further meetings, because this proposal is etched in stone and it cannot be changed. It's final. I do think that the Undersecretary give a consolidated answer when the deputations and individuals are here. It would be better. You only start discussions with them after the legislative amendment is endorsed. That means nothing will change. Then there is no need for have further meetings. Just let us vote on it next week. And we've heard from deputations that they are willing to explain to you clearly their position, so that you'll understand why they think there needs to be some changes. And as I say again, that is not a dispute. Well, for the textile and garment is an additional one. And for the IT sector, it's already there. So their status is recognized. It's just that for some reasons they are not eligible voters. And they just want to talk to you and explain their case to you. Well, I'm afraid we can't invite them to give their views again in the Bills Committee meeting. Perhaps you can arrange to have a meeting with them before you make a final decision, at least decide whether it can be changed now or it will be a future amendment. Just now, some deputations from the textile and garment industry and the IT industry gave us some comments. And in the last time when we proposed amendments, we have already explained our decisions. We're asked to consider it and to discuss it with other policy bureaus. And we've stated that we have consulted other policy bureaus. So we have more or less completed the procedure. When I said a reply is not about a decision whether to accept it or not. It's just a written reply. Mr. Mark. That means you have turned a deaf ear to them and you refuse to change. Because some deputations said that they don't expect you to start doing it immediately. At least they would like you to at least listen to them. The CMAB refuses to talk to them. So is it the case that you suggest that they go to the CEDB and the OGCIO to talk to them first? To ask them if they told the CMAB that there can't be any changes? Is it the case that you ask the deputations to go back to talk to their relevant bureaus first? And the Secretary, last time I have explained and I have actually replied to Mr. Mock that the CMAB can't possibly know about the situations of all the different deputations, so we rely on the Policy Bureau to give us their comments. And so far the situation hasn't changed. Well, my question hasn't been answered. Perhaps we have to ask the CEDB if they would like to talk to them and ask them whether they have rejected the requests of these deputations and said so to the CMAB. And as you've heard from them, that they are often engaged when it comes to organization and activities, but when it comes to changing the FC, they have been neglected. If you tell us that, then yes, we will go to the CEDB. Mr. Porte, sorry I mixed up the two files and I'd like to focus on this one. Well, let's set aside the despise of the FC by 10 Democrats. But if we don't do our best and if we don't strive to improve, then we'll be seen as a monster and we have no one to blame but ourselves. I was once a member from the FC. I fully understand the representativeness and the problems of GC and FC. We always talk about representativeness. Well, the FC, apart from representing their own respective sectors, perhaps they can do better to increase their representativeness. But it seems that the work has been taken up at a snail's pace, and sometimes they don't even give a courtesy reply, and that is unacceptable. If you want to be conservative, if you want to have a orderly and gradual progress, you at least will have to have some exchange with the sector. Don't just shut them out and keep saying no to them, because that is unacceptable. Mr. Ma and I myself have cited some examples when it comes to, say, the classification. There was some rushed approach. Just some sectors have been lumped together, but times have changed. So you will have to improve on the classification. I'm not going to repeat what Mr. Ma has said. Say the tourism FC. Why would there be tourism agencies, hotels and airline companies? But when it comes to the CE election, hotels has been moved to somewhere else. People can't understand and work it out. Just now, a deputation asked a question. Mr. Wu said that if it's someone from DC, why does it have to be stuck to DCFC and not, say, a legal FC? Well, because of, it was said that because of the limited numbers in the district councils and in order to enhance representativeness, so district councillors can only be representatives of DCs and they can't choose to vote in their original functional constituency. At least there's an answer and you have to give an answer, but you didn't even attempt to give an answer, and that is unacceptable. You may be conservative in your political stance, but you still have to deal with some practical issues. You have to try to explain, try to improve it, so that people will not resort to knee-jerk reaction and reject it. You have to explain to them. Even when they are impatient, at least they will listen to you. There is nothing done with the FC. I understand that in the past there are some members from the FC. They have been doing something, say for example, one from the shipping industry. That person tried to increase the number of voters in the sector. And I don't know whether the Undersecretary will say, well, it's close to an election, we don't have time, let's wait for the next time. I don't know whether this time there will be even the slightest amendment. Well, on representativeness and the reduction of the risk of being manipulated, we have to strengthen the FC so that we have a leg to stand on when people say FC should be abolished. Mr. Porter and deputations have made some points about FCs. I think we can, yes, look into them. But this time is only a technical amendment. And we're willing to reflect your views to the Secretary. Mr. Raymond Wong. Thank you. I don't even understand why I joined this Bills Committee, but my assistant said that, well, because it's something to do with election. I think it's completely meaningless because it's technical amendment, and we're still talking about functional constituencies, and some members of the EFC are pan-democrats. Well, it should be abolished, and if you abolish the EFC, I will support the constitutional reform, as I've always said. But you want to perpetuate the FC, including some pan-democrats, and I think it's just incorrigible. This time round, there are some technical issues, technical amendments, let's say, for example, the nomenclature in the architectural surveying, planning and landscape FC, and some technical issues, of course. The relevant trade will have a lot to say. You want to speak because you want to keep the FC. I find it acceptable if it's said by loyalists, but if it is pan-democrat, then I find it quite unpalatable, because it seems that you want to perpetuate the FC. And I would like to talk about the vote counting procedure. Well, I'm not really interested, and this is a technical point, but it's worth our discussion. I have some questions to ask, and I wonder if the Secretary can answer. It seems that you're a bit lackluster. Why? And your voice has gone soft. I can hardly hear you. Well, Lau Kong Hua, you've been quite brave before. Is it because you were tired out by the constitutional reform? Paragraph 9, in relation to the counting procedures of DC, talking about the electoral brief. Of course, it's information supplied by the government. In relation to DC's second counting procedures, some technical amendments and verification of ballot paper, account, Is it the case that there is one less time to verify votes, Mr. Lee? Under the election procedure, in relation to the counting procedure for DC 2nd FC election, and in relation to ballot paper coming from a small polling station or dedicated polling station, currently there is no specific provisions. So, in relation to ballot papers coming from small polling stations or dedicated polling stations, we would like to clarify the counting procedures. We would also like to align it with the procedures in main polling stations. So, ballot papers coming from small polling stations and dedicated polling stations, because of the small number of votes and because of confidentiality, when the ballot papers go to the central counting station, they have to be mixed with ballot papers from other polling stations before they are counted. And in relation to the counting procedure and the number of times, this is the same. Well, when ballot boxes from small polling stations and dedicated polling stations, first of all, the number of votes will be counted before they're mixed with other ballot papers at the central counting station. In this way, we can ensure that we can verify the number of ballot papers, and we can also complete the counting procedure.
Mr. Raymond Wong, yes, we feel sorry for the electoral staff because they started at 5 or 6 in the morning, and usually the counting can only be completed the following morning. So for the officers and the electoral staff, they have been on the alert for 20-30 hours non-stop, and they must make sure that no mistakes, no errors have been committed. So you need to be very concentrated in your attention to all such matters. Why don't you make changes to the system so that they will be spared the difficult task? Now you want to simplify the counting procedures. What's the purpose? Is it because you feel sorry for the working staff and you want to ease the burden? I think if you haven't got sufficient manpower, you need to try to get more helpers. And then for schools and community halls, they act as counting stations and polling stations. Why can't you make arrangements with them? Why can't you sort of make it a public holiday? In Taiwan, they are talking about 20-30 million votes, and yet they are able to finish the counting in a few hours' time. Of course, there's no comparison with Taiwan. For us, the pace is very slow. I think, first of all, you don't have that much space, you don't have that many polling and counting stations, you don't have that much manpower, and this may easily give rise to mistakes. I think your time is up. Mr. Mock, maybe you can speak for the second time, Mr. Wong. Well, Mr. Chairman, if I may comment on the point about gradual progress as referred to by Mr. Alan Hu. I think what he was trying to say was that if we have to wait for universal suffrage for the election of the CE and then the composition of the electoral, it means that it is too truncated, too piecemeal, and we can't make any improvements. I think we must make something happen for 2016, and then otherwise 2017 would not bring about any hope. Now for the FCs, we need to convert the corporate votes into director's vote. I think this can be done. Do it, and then you can convince others that it is more representative, and probably the citizens will support you, and then you get more supporters. So why don't you grab this opportunity to do so? I think that's what Mr. Hu was trying to say. Of course, in the society, there are different views on this matter, but my question for the government is, why haven't you done this much earlier? consult the people, and then for the remaining time, you just focus on 2017. Now with so little time left, we haven't got time to do much about 2016. And for 2017, I don't think it is going to happen. I think even if you say that it is not intentional, but then the objective outcome is that for so many years, for the electoral elections, for the CE elections, and the election committee sector and subsector elections, we haven't observed much improvement. So changing the votes into individual votes, and in fact Mr. Hu has also said that the electorates can be expanded by giving votes to the professionals in a particular sector. Why don't you do it? Why don't you at least include it in the agenda for discussion? Now the government has always adopted such a position. Is it just because you just want to stall the progress so that every time it is kept stagnant, and so everything will be perpetuated all the time, forever? And the Secretary, Mr. Chairman, for the political reform consultation exercise, indeed, the electoral election in 2016 and the CE election in 2017 were both made the subject matters of public consultation. It isn't quite like what Mr. Mok has said, that is, there wasn't any consultation at all. And then secondly, for every term of the SARG, you can see that every time it is being initiated by the current term government, it will be difficult for us to impose anything for the future term of government. So Mr. Mok may get the impression that we would only be considering the elections for the coming term. And for the upcoming political reform package, it is not piecemeal. In fact, we have a timetable with a roadmap. And in fact, the NPCSC has already said that we will start with the election of the CE, to be followed by the electoral elections on the basis of universal suffrage. And that's why you can see that we very much hope that there will be universal suffrage for the election of the CE in 2017. Yes, there may just be 10 days left for the voting on the matter. Things may not look that satisfactory. We still hope that in the time remaining, we can lobby the support, including the support of Mr. Mok. We are on this bill. Please don't talk about lobbying. I think he knows it. It is related. I'm still answering the question. They are really relevant. Now, for Mr. Mok, if we would like to have an overall review of FCs and also universal suffrage for the election of electoral members, I think the prerequisite is that you need to support the package for the CE election. Mr. Chairman, I think he has tried to divert our attention. Can I continue, or should I wait till the next round? The Undersecretary was trying to answer your question. But in fact, in the first place, your question has gone beyond the scope of the bill, so it is difficult for him whether to answer your question or not. Today, I've been very relaxed, and I have allowed questions to be asked. You are concerned about the general issues, but I think all the general issues have been covered. The bill itself has a very narrow scope. It is about technical amendments. It's about the names of the electors and also the change of name of its FC and some changes to the counting procedures. So they are technical in nature rather than something in the nature as described by you in your question. Yes, of course, you can continue. For the scrutiny of the bill, If you want to express any views, I will try my best to accommodate your needs, but I have to remind you that we need to come back to the specific scope of this bill. So maybe gradually I will tighten up. Mr. Chairman, just now, I was wondering whether the corporate votes can be converted into director's vote. I have not attempted to extend it to individuals' votes. And then just now, deputations have said that perhaps the electors should be the professional voters in the relevant sector. Now, we have been told by the government that we need to work on the C's election and the nomination committee first before we can move on to the LC elections. But I don't really think so. I don't think this is stipulated in the basic law. All it says is that, first of all, we have the C election and then the LC elections on the basis of universal suffrage. But I think all the FCs are related. So how come that we can't do something about it in the context of the LC elections? The Undersecretary also tried to argue with me as to whether the consultation exercise covered the LC elections. The fact is that part is relatively shorter. And then we've always been told that within the term of a government, you will only deal with the following term, and then the rest of the time should be spent on livelihood issues. I just want to know why you won't do this first instead of leaving it till the end, and then you would only bring it up along the way when we are having the election discussion. Well, corporate votes to be converted into directors' votes. But I don't think this is within the scope of the bill. But then you are concerned. It hasn't been proposed by the government. Yes, exactly, Mr. Mock. You need to read the long title of the bill, and we are bound by the long title of the bill. But I haven't barred you from referring to this. I just want to remind you that this is not exactly within the scope of the bill. Under Secretary, it is clear that the amendments in the bill are technical in nature. Just now, there were references to the need to reform the FCs. I've promised to take them back to the Bureau, and in future, the panel will have a discussion. Under Secretary. Now, for this bill, certainly the bill is silent on those points. We can't move any amendments because it will be beyond the scope of the bill. Of course, maybe this point can be raised at a meeting of the CAP, but in the short term, are you going to give us another opportunity to explore this matter? Are you going to propose amendments? Mr. Chairman, for the bill before us, it is an amendment bill. We are not going to move amendments concerning other FCs other than those already in the bill. As to how we can improve the FCs, it is something else. I'm sure the CA panel can certainly have a discussion. Well, for the electoral legislation bill, now, for the 2017 CE election, there will be the nominating committee rather than the election committee. For the 2016 LegCo election, I understand that there's still room for discussion. Many members have already spoken, so I hope that you'll gather the views of the LegCo members. Please consider whether you are going to address our concerns and review the other provisions and propose amendments concerning other electoral laws, but of course not within the bill before us, because for this bill we are already bound by the long title. I'm sure you have heard our views. I recall that at CAP meetings, many members have spoken a lot about the 2016 election. So what are you going to do about that? Are you going to give an overall reply? At least state clearly whether you are going to make changes or not. We expect an answer from you. Mr. Chairman, I thought that at the panel meetings and at the Bills Committee meetings here for 2016 electoral elections, we do not intend to make major changes. I think this is clear to everybody. It is also part of the NPCSC decision, and that's why we have got technical amendments here. Mr. Chairman, of course, eventually we have to work on the domestic legislation for 2017 CE election. Concerning the various sectors and subsectors, probably members will raise the questions. So there will be an opportunity for us to exchange our views. All right, it is already 4:30. We need to finish our meeting.
We had a lot of discussions on issues of concern to you. I hope the administration will give us a written reply. The next meeting, starting from the next meeting, we will have clause by clause. You may express your views during the clause by clause. The next meeting is on the 15th of June, which is a Monday at 4:30 in the afternoon. Thank you. Meeting adjourned.